Wow, what the hell was that? Welcome to part two. Welcome to part two of the breaking Maya Kowalski trial. Plaintiffs demolished defense with crushing response. Welcome to part two. Holy shit, what was that? Oh boy, my wow, that was a yeah. Here's what happened if you were watching part one and it just suddenly ended with me going, "Oh God!" Did the "Oh God" make it? Yeah. I'm I'm watching this thing, literally just getting ready to read, and for some reason, I just see this stream ended. Your voice cracking is the best. Yeah, I'm going through puberty now. Turn your head and cough. Exactly. I just started going through puberty. Yeah, I was just watching this and suddenly, if you like on StreamYard, when you end the stream, it flashes up this little sign that says your stream has ended. Like there's like an end stream button, and if you click on that, it goes kind of gray, and then a couple of seconds later, it says the stream has ended. Return to the dashboard. I was watching this. I was just getting ready to read this next section, and I saw the end stream box go gray. Not a clue what happened. That's why I'm like, oh God. And then, yep, sure enough, it ended. So that's why we're here. Oh, Darth, I would love to embrace that boomer moment. This was some serious voodoo bullshit out there. All right. Well, anyway, I'm going back to hear the voice crack again. Oh, yeah. Wow. Yeah, I got nothing. That was just wild. All right. Anyway, we've got a few pages left here. We got 10 pages left, and we're not, of course, not going to read all of that. So this will be a short part two. Part two, nonetheless. Welcome to part two. Linnea, bus stop juror, totally thought it was your fault. That's just because you're just a bus stop juror. Wow. All right, I'm confused, I'm perplexed, but not going to let that throw me off my game because I'm the Law Rax and I'm a professional. And the more I do that, the worse it's going to make my voice. Anyway, welcome. If you're just not joining, please go find part one to this. It was just before, but somehow ended quickly. All right, part two. Let's wrap this up. But before we do that, I have no idea how the poll ended on our last stream, but I'm sure it pretty ended. And thank you all for the super chats there. God dang it, that was wild. All right, how many people do we have suffering through this one here? I got to go back and pull up the live stream here so I can monitor it. There we are. Oh, got to just give me one quick second to correct my shiz here. That goes to Maya and upload a thumbnail. Where's the Maya folder? The today folder, all right, there. That's saved. Yes. All right. That's good. We're ready to go, ready to rock, ready to roll. And bring that up so I can see what's going on the stream. Hey, 248 of you made it back here. The other 700 just like, what the hell happened? He pieced out on us. Sorry, everybody. I have no idea what happened. All right. Volpe Fox, thank you so much for the $5. Oh, God, cackling. Also, love getting the Legal Vices posted a new video notice from the Free Zachariah Discord. Well, righto. Well, Legendary Racing, Ghost is a boomer too, right? I honestly, my hand, the cursor never goes up. It's right. The end stream button is right up in the very upper right corner of the box. It never goes up there. Ghost is a boomer too. Thank you so much, Legendary Racing, for wasting your 9-month member free chat on that. And it's happening with Harper. Thank you so much for the $2. It was obviously your Ghost that did it. It was something. I don't know. Jennifer, did you let Megan push all the buttons? Fox administrative rights. Yeah. No. All right. Well, that was weird. That was wild. Let's get back to this. Now I got to bring up all this crap again. All right. Here we go. That should set us right. There's that. Bring me on down here. All right, should we get through the last 10 pages here? Yeah, apparently 700 of the chatters ran off to get some of that Headhunter 37.5 cannabinoids. I don't even know what that means, but okay. Jeff, don't look behind you. I can see behind me in the camera. So, yeah. If ghosts don't show up on the camera, they're not real. Yoda used his force because he wants to cuddle. Yeah, pretty much. All right. Let's do this. This is the last section of the 89-page memo. For the previous 78 pages, go check out part 1. Issues. Try that again. Issues. It's a weed thing. Well, I know. That's all I know. Legal. These are issues affecting the claims represent. Boy, I am rattled. I'm shooketh, as you kids say. Issues. I'll never say the word shooketh again. I swear to God. Issues affecting the claims presented by the estate of Beata Kowalski. Intentional infliction of emotional distress. This was all about calling her. We're telling your daughter she has another mother, etc., etc., etc. The court's gatekeeping stuff. And is this all the stuff we're going to read? We have to read all that, don't we? Yeah. All right. I was just previewing it to make sure that's what we were doing. All right. Nah, we don't need to read all that. That's the billing fraud stuff. We don't care about that. There we go. Plaintiff will elect the wrongful death claim, but responds to defendant's legal arguments, which it adopts for the wrongful death claim. Defendant's factual spin ignores the concerted action harming Beata, immediate retaliation against Beata for challenging defendant's doctors and urging them to discharge her daughter, refusal of the family request for discharge, and false imprisonment of her daughter for having challenged defendant's doctors. Another woman, defendant's social worker, kissing and touching her daughter while telling Maya she would be her mother and that Beata was mentally ill and that she'd been placed in a mental institution. The same social worker suggested divorce to Beata's husband, interrupting phone calls between mother and daughter and isolating Maya, denying her cards and gifts from her mother, etc. Defendant then poses another rhetorical question. What evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of human decency, atrocious conduct utterly intolerable in a civilized community, and did so with the intent to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing that stress? That was a question posed by the defense. What evidence is there that somebody did that? Well, here's your evidence of that. The answer is easy. Defendant's doctors exchanged text messages in which they predicted Beata's suicide, having had another mother do the same thing. This was not their first rodeo with the self-delete wagon. They'd had another mother do the same thing, and they predicted Beata would do this. Dr. Laura Vose, who testified by deposition at trial and bizarrely served on Jay Hatch's ethics committee in 2016 and as co-chair of Jay Hatch's ethics committee in 2017, texted Dr. Tepa Sanchez shortly after Beata's suicide to relate that in the lead up to Beata's ultimate demise, she had predicted Beata would take the final step. Whether this evidence is intent to cause Beata severe emotional distress or reckless disregard of the high probability of causing Beata's suicide is a question the jury did not have to answer. Either way, defendant's ethics committee had actual knowledge of Beata's severe emotional distress and failed to intervene. Defendant lashes out at plaintiff for having resorted to a great conspiracy, a plan akin to a Mission Impossible episode. But defendant then weaves a theory that plaintiff did not argue and ignores that the court granted defendant's motion for summary judgment on plaintiff's count for civil conspiracy relatively early in the case. As explained above, the court ruled in defendant's favor when it renewed its objection to Dr. Newberger's mention of a conspiracy and excised that testimony. Defendant waived any other argument that this lone utterance of the word conspirator elsewhere in Dr. Newberger's testimony justifies a new trial. Since defendant did not renew its objection to that word or testimony and did not ask for a curative instruction after Dr. Newberger's testimony was read, further, one utterance of the word conspirator in the context of a 9-week trial is harmless error, if error at all. Plaintiff argued before trial that I was off in Murdoch land there. Plaintiff argued before trial that Beatty was the hospital's hitman. But that term and other similar terms were excluded when the court granted defendant's motion in limine. In short, defendant's elaborate doctor's revenge novella is not a rehashing of evidence presented to the jury, but rather defendant's attempt to paint the jurors as conspiracy theorists. Although there was evidence from which one could infer that a doctor's revenge conspiracy existed, plaintiff did not argue that theory. Rather, plaintiff focused the jury on multiple, atrocious, intolerable, extreme, outrageous acts. The actors included Ms. Beatty, Dr. Vose, Dr. Lightning Bolt Smith, Dr. D's Nuts, Dr. Tepa Sanchez, Dr. Dolan, and last but not least, J. Hatch's Risk Management Department and its senior counsel, Jackie Crane. Not Jackie Chan. There were likely others involved, although the notable absence of any testimony from a risk manager of Ms. Crane leads to the natural question. If defendant's straw man, Dr. Revenge conspiracy theory orchestrated by risk management was so easily disproven, why did defendant not call anyone from risk management department to testify, especially considering the prominence of the damning risk management notes throughout the trial? The standard instruction given by the court do not require that Beata heard or witnessed the cruelty in person. That was their big. That was the question that was asked above. Well, what did she see? She was elsewhere. She was far, far away when this happened. So how could it affect her? She wasn't required to witness it directly. And the court has rejected adding that gloss to the law. Defendants' actors had to expect Beata would hear about the taunts of Beata losing her child, her husband, and her freedom being committed, and the harms they inflicted on her 10-year-old daughter. So they had to assume she's going to find out about this one way or the other. Defendant not only attacks the plaintiffs for a conspiracy theory defendant alone has articulated, defendant then attacks this court, and it did as it did in open court for not performing its gatekeeping function. For defendant's desired list of actions, it need only look at the highlights of its actions above. The 8th amended complaint, the order granting leave to assert punitive damages, and the response to defendant's motion for summary judgment. A simple list, however, does not capture. This is talking about that list we read at the beginning of part 1, which is the long list of really horrific things they did, which wasn't a complete list. That's what they're saying here. This wasn't a complete list. This was just a simple list, and it doesn't capture the relentless frequency of this conduct. The death by 1,000 cuts. The jury was entitled to infer defendant orchestrated the conduct, perhaps to deal with a mother who offended or challenged the wrong people. Those being unqualified doctors wearing J. Hatch lab coats, Lightning Bolt Smith, talking about you, girl. The court exercised its gatekeeping function through the trial by excluding Beatty's correspondence documenting that she and the hospital were pushing for further restrictions on Beata's visitation rights without justification. Beatty's arrest record, yeah, that's right. Beatty's been arrested. What's she been arrested for? Beatty's arrest, this was all suppressed. Beatty's arrest record for physical violence on a child similar to Maya's age. And excluding the presence of that arrest record in Beatty's personnel record, reflecting and proving without a question that defendant knew of Beatty's violent history. Defendant's counsel cease and desist letter to Mark Zimmerman to avoid the jury learning that defendant drove the dependency proceedings, and the sexual assault of Maya documented in defendant's medical records, and the failure to report that sexual assault to Florida Abuse Hotline, which was another outrageous conduct the jury could have considered. The jury was instructed on substantial cause, and defendant's unsupported statement to the jurors could not sort out the cause is just that, unsupported. Defendant's professed inability to see the disdain and hatred the ketamine girl text evinces reaffirms the defendant just does not get it. Equality, it wasn't just that one. She has 3 charges against her. Again, they hammer that home. The defense just doesn't get it. Defendant will indeed elect the wrongful death claim over the survivor claim, so nothing more needs to be said about survivor's damages. The intentional infliction of emotional distress causing death by suicide. That's also their big question. How did what this happened so far away from her cause her to self-delete? Well, defendant continues to recast the facts in a manner the jury loudly rejected. Leading up to Beata's suicide, defendant continued to inflict psychological and emotional blows on Beata. In the 30 days leading to Beata's suicide, a time frame defendant focuses on, defendant 1 ignored Beata's request to have Beatty removed from Maya's care. 2, then allowed Beatty to molest Maya in the chapel. Gotta keep reminding myself I'm only 17 minutes into this new stream, not 3 hours in. Yes, when it's happening with Harper. Yes, when we're done, we'll be sending it to Megan. Don't worry. We're almost done, and we'll send you there real quick. They ignored Beata's request to have Beatty removed from Maya's care, and then allowed Beatty to molest Maya in the chapel. Refused to allow court-ordered visitations by phone and FaceTime, isolating not just Maya, but inflicting further severe emotional distress on Beata. 4, refused to facilitate family therapy sessions ordered by the dependency court. And 5, ignored Beata's medical decision-making rights that had been preserved for the dependency court and tormented by Beata further by threatening to remove Maya's port. 6, did not allow even a single FaceTime call between Maya and Beata in the last 10 days of Beata's life. Despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls both at 11 a.m. and 5 p.m. each day. And 7, then directed Beatty to threaten Maya that she would not be allowed to attend court and see her mother if she did not submit to stripping for Beatty and subjecting herself to semi-nude photographs. Beata was the target, and she knew it. Beata was the target, and she knew it. Jack testified to learning of these actions directly from Maya and relaying them to Beata. Q. Now jury may hear testimony from your daughter about Ms. Beatty's physical contact with her. During these conversations, was Maya ever allowed to tell you about those? Answer by note. Question. And so, what was the effect on you and your wife about knowing what Ms. Beatty was doing? Answer. It was just putting a bigger wedge in between everyone and more anger. Question. Well, was Beata becoming more desperate at this point? Answer. Yes. Question. And what was her concern? Answer. Number 1, Maya's health. Question. And were you reporting back to your wife about her health every time you visited? Answer. Yes. And yeah, it was difficult. Question. And we're going to refer to some covert video at this point in a moment, but going back to the dresses, who picked out the dresses for Maya? Answer, Mom. Question, so what was the effect when she heard that Maya couldn't even get her dress? Answer, it crushed her. Question, from everything you perceived about your wife, how upset was she when she found out that her daughter was being treated this way? Answer, it was extremely difficult for her. It was taking all the air out of her balloon. I mean, you could see that it was just eating at her. She lost a lot of weight during this time. Beata learned of much of this directly, even when her visitations were routinely shut down by Beatty. Instead of focusing on these horrific acts, these horrific facts, defendant plays the same game it did at trial. hiding its head in the sand, rather than attempt to explain how it was that Maya didn't have any FaceTime calls with her mom in those last 10 days, despite the dependency court's December 27th order expressly requiring those calls. Defendant instead focuses on a couple of photographs taken on or just before Christmas with Maya smiling and holding a present. The same approach failed at trial, when defendant opted to ignore Beatty's horrific actions and instead played a video of Maya playing piano in the hospital lobby with an unidentified physician and exclaiming, "This is Johns Hopkins." The jury rightly rejected defendant's saccharine version of the events when plaintiff played defendant's horrific, outrageous acts with the correct motto, "This is the real Johns Hopkins." Boom! Gotcha.
Gotcha, bitch.
Defendant's public policy threat to this court is preposterous. Quote, "If the court does not grant relief on this claim, no rational hospital administrator will be willing to keep a child in DCF custody for any period beyond the point where the child is eligible for medical foster care. Rather, Florida's public policy will be served by reinforcing with rational hospital administrators that hospitals cannot falsely imprison children without legal authority, should not covertly videotape children, should not entrust sheltered children to the care of violent social workers with criminal histories, should not direct the battery of children in their care, and if the administrators are aware that their actions are driving a mother towards suicide, they should address the hospital's failings, not hide them." How any of that shit we just read is not goddamn common sense and not something that should just happen. You shouldn't have to be told that. It should just be natural. And my voice is shot to hell. Well, that, ladies and gentlemen, brings us to the conclusion. Defendant re-argues the same positions the jury rejected, continuing to deny the horrific nature of his actions. Plaintiff Jack Kowalski, individually and on behalf of MK, a minor, and as personal representative of the estate of Beata Kowalski, deceased, respectfully requests the court deny defendant Johns Hopkins All Children's Hospital's motion. Dated 11th December, 2023. That brings us to the end of that. Wow. Torin 3, thank you so much. Member for 3 months already. Wow, J Hatch hacked your stream and ended it to shut you up. I think it was you because you're probably you because I think your super chat was up when it collapsed. I think. Anyway, whatever. Thank you again for your nice words. I'll get it mailed to your PO box by Friday. Hey, take your time. Appreciate it. And E Koala T. I have to get a police clearance certificate to volunteer at my kid's school. How is CB allowed to work with kids? Well, she was, and it ended up as contributing to costing J Hatch $261 million. So perhaps they'll rethink that in the future, but she is still listed on the hospital staff webpage. So take that for what it's worth. See if you learned, if you think they learned anything from it. But well, that's going to wrap up part 2. the unplanned part 2. 353 concurrent viewers. We got like 1/3 of you back. There's still like 2/3 to go. Wow, what a dick. You're just like, oh God, and he peaced out. All right, well, I'll put up a part 1 and part 2. Part 2 to all of this. Do I have a prediction on how the hearing will play out on Friday? Like I said, there's 5 or 6 different things they're going to be arguing, and the court has allotted, I think, like 30 minutes for this motion, 20 minutes for the juror misconduct motion, 10 minutes for some other things. Well, I mean, what's going to happen is he's going to say, thank you for your arguments. I'll take them into consideration and issue a ruling in due course, because he's not going to make any decisions tomorrow. He's already said that. So the decision will happen later, but I guess what you're asking is, what will the decision be? Because what's going to play out at the hearing is that both sides are going to give their arguments and the judge is going to say thanks. It's going to be half a day. How I think it's going to turn out on the two big ones, the motion for a retrial and the motion. I mean, the motion for a new trial based on juror number one's misconduct. That's going to get the double guns denied whenever that comes down. That's going to be just denied outright. I can't imagine that the court will even give much I can't believe the court will give much comment as to why it's so absurd. It's so patently ridiculous that, that should just be dismissed almost without comment. This is going to be a little bit longer, but I believe all of the motions from the defense will be ultimately dismissed. I mean, there's a very slight chance the court could find that some of the super high amounts were excessive, but I don't think there's sufficient grounds for finding that, and I don't think you will. But you can't completely rule out that possibility. And with that, it is now 2:24 a.m. Time for me to get a nice glass of water and call it a night. Thank you for sticking with me and coming to find part 2 here when God knows what happened to part 1. It just kind of went dark suddenly, and I'm like, oh God. Thank you for that. Don't forget to hit the like and subscribe. This one as well. Hit the like button. We got 194 likes, none of which I deserve for this. But hey, coming up tomorrow, we've got a new trial starting. It's the trial of Bryce Rhodes, charged with triple murder of one man, 40 years old, and 2 teenagers, one 14, one 16. That should take 2 or 3 weeks. Opening statements start tomorrow. We'll be covering that gavel to gavel. Coming up on Friday evening U.S. time will be my F It Friday, where we just say, F it, you bring all your money. It's a major griftathon. We have a big panel of people, including Law of Self-Defense, Andrew Branca, potentially criminal Sean, Andrew Esquire from Legal Mindset, Chandler Remington, Danny on Flux, Sally from Talk with Sally, Nick Ricada, Hayden from Aussie Overlord, Nicholas Starr of Lady Law from Lady Law 5791, Natalie Wisco and MG Law, and others to be announced. And then we'll start with the trial again next Monday, and go whatever the court schedule is for that. So thanks all for being here. We'll see you tomorrow. Same bat time, same bat channel. Hopefully only one part for tomorrow. Yeah. I ended the stream to like farm. Yeah, I wish that was a thing. All right, everybody. Let me boost us up here. We got to send you on over to what's her face, Megan Fox. She's doing something, so let's direct you all over there. Hang on, real quick. Oh God, that was terrible. Part 2, duh. I have no idea what happened. That was just wild. Redirected to Megan Fox. There we go. And save. Oh my God. Yeah, this is a new case. The Hernandez medical kidnapping. Not unlike the Maya Kowalski case. So get on over there and find out more about this trial with Megan Fox. Until tomorrow, until the Bryce Rhodes trial. Thanks for putting up with the shenanigans and sticking with me through whatever the hell that was. We'll see y'all tomorrow. Take care. Make sure you enjoy your legal vices. Law Rack saying peace. Oot.